In terms of an overview of what I'm going to speak about, first of all, I'll just briefly introduce EDO. I might take questions about our funding issue and leave that just for a little bit later. And I'm going to talk about public interest lawyering, because essentially the work that we do is really representing the environment and, as I said earlier, being lawyers for the environment, and that's very much connected with public interest law and public interest litigation. I'll also talk about features of New South Wales environmental laws, picking up some of the issues that Michelle has already touched on from a New South Wales perspective, and just critiquing those laws in line with what we'd like to see from an Earth law perspective. I'll touch on standing, that's the ability to actually bring litigation into the courts on behalf of the environment. And because I am an avid litigator, I absolutely love going to court. I will be talking about Warkworth, which is a very big win that we've had recently. It's been in the papers and you'll probably already know a little bit about it, so I can tell you more about why that's been a really significant case. And I will then just have a quick look at that case from an Earth law perspective and just critique it and see how far the court has been willing to go in that case. Michelle talked about the sort of dichotomy, I guess, between law and governance, and I guess there's a struggle a little bit between the courts sometimes and the court's role of interpreting the law and how adventurous they can be where they're constrained by the legislation and how it's set up. So I think that we can talk a little bit about those issues in the context of the Warkworth litigation. So as I said, Lawyers for the Environment, the EDO is a community legal centre that specialises in public interest environmental law. Lots of people think we're government or funded by government, but actually we're not. Our funding comes through the Law Society Public Purpose Fund. And so we are independent, which is a really great place to be, particularly where you have, you're bringing cases against coal seam gas and coal mining. And our mission is to empower the community to protect the environment through law. You may not know that there's an EDO in every state, so it's not just New South Wales that has this fabulous organisation. There's one in, I think it's every state, isn't it? So in New South Wales, as Michelle said, environmental laws are often very limited and very far from what we'd like to see from an Earth-centred perspective. One of the features is that they tend to be anthropocentric, which is humans first, and also development focused. Most of the planning and environmental laws in New South Wales, as in many other, in fact probably all of the other states and territories, it's very much about weighing up numerous competing objectives. So rather than having the environment first and other factors sitting below, decision makers on new development, etc., need to participate in a sort of weighing process where the environment is balanced against other interests such as social and economic. And as you will all know, usually it's the economic benefits, so-called, of a project that will come out on top. Many of you will know the concept of ecologically sustainable development, or ESD. And that has been, I guess, a concept that many environmentalists and many environmental lawyers have pinned a lot of hopes on. And there has been many cases, and some of them that I've run, trying to make ESD more prominent in the decision-making process. The problem is that, and we'll look at an example shortly, ESD is always just one aspect of the decision-making process. So not only are you weighing the economic, social and environmental, but then ESD itself it involves a weighing process within itself, but it's also only one factor. So the environment just starts to trickle down to be, a less important factor in the weighing process. Cumulative impact obviously is becoming more and more important as we're seeing far more development being carried out. For example, the mines in the Hunter Valley are starting to cause real problems for air quality, and those cumulative issues, it's really hard to deal with because legislation doesn't really know. I mean, it could, but at the moment legislation doesn't provide a guidance for how to deal with cumulative impact. So that's something that the courts try to grapple with, but it is something that's ignored essentially in the legislation often. And I just wanted to give you an example. I know that a lot of people at the back may not be able to read this, but I'll give you an overview. This is the Environment Planning and Assessment Act, which is probably one of the key pieces of legislation, because although we have so many environmental laws, it's really planning laws that sit beneath all of those environmental laws. And I say to students, studying planning law was always so dry and so boring, and people find it so dry. But I say to students, it is so important to understand it, because that development assessment process under the planning legislation, and also the way that the legislation deals with zoning and setting up that strategic kind of approach, those concepts are so important and really set up, I guess, the landscape for how other environmental laws fit in. So under Section 3 of the planning legislation, you'll see that this weighing process comes in. The objectives are proper management, development and conservation of natural and artificial resources, including agricultural land, natural areas, forest minerals, water, cities, towns and villages. You can see the anthropocentric perspective coming through there. Promoting the social and economic welfare of the community and a better environment. I mean, how do you weigh those things? They're competing priorities often. 2, promotion of orderly and economic use and development of land. Communication and utility services. Further down, ecologically sustainable development. And then provision and maintenance of affordable housing. You can see that there's so many different social, economic and environmental values in there, all as objectives of the Act. And it's such a challenge for decision makers to weigh all of those things. Obviously from an earth-centred approach, you want at least ESD to be at the top as a sort of mandatory consideration, rather than as just one of those weighting aspects. Or even better than ESD, just having safeguarding the environment as something that comes before everything else. That would be much more in line with an earth-centred approach. So as Michelle explored as well, it's really all about a presumption for development. I'd love to think that that picture was a bit more realistic, but actually I'd probably put the scales the other way. Very often it is, development is approved, and it's more about managing environmental issues through conditioning. And so very often when you run proceedings in the Land and Environment Court, there's always that feeling that the development probably is going to be approved, and it's all about fighting for the best possible conditions that you can get for the environment and safeguard in that way. But obviously it would be much better to think that the environment would be weighted more highly. Many of you may wonder, well, how is it that the environment gets a voice in court? How do we even get to have these cases? I guess one of the good features about environmental and planning law in New South Wales, that many of them have what we call open standing provisions, and that is basically enables any person to bring proceedings for an order to remedy or restrain a breach of the legislation. So that's what we call open standing, and it means that any person, it doesn't matter if you've made a submission on a development, it doesn't matter if you live next door or if you live in another state, you have a right to bring proceedings on behalf of the environment. Obviously it's open to people to bring proceedings for whatever reason, but the clients that we have are community groups and individuals who represent the environment and are concerned about the impacts of development on the environment. It's also important, I think, to have a specialist court. and that's a real advantage in New South Wales. The New South Wales Land and Environment Court is a leading court, and it's renowned worldwide for developing jurisprudence in environmental law. And it does mean a lot, especially from the point of view of being a litigator. When you appear before a judge, you don't have to explain what ESD means. They actually know what it means, and you're kind of a step forward already, at least in having that discussion. Some of the barriers, as you can imagine, for litigants who bring proceedings on behalf of the environment, costs is always a big issue. So, for example, if you sue a coal mine, the mine can seek security for their costs, so that if you lose, they're not going to be left with the bill. Usual cost rule in the courts is that if you lose, the loser pays the winner's costs. So these are barriers, and one positive thing is that the court has a public interest cost discretion, and that means that the court can exercise its discretion to not order costs against a public interest party if they are unsuccessful. And just briefly touch on the kinds of litigation that can be brought. Judicial review is a challenge to the decision-making process. So really, it's a challenging proceedings to bring, because you have to find some sort of chink in the way that the decision has been made in terms of its process. Merit appeals, on the other hand, they challenge the substance, or the noise issues. If it's, I'm going to talk about an open-cut coal mine, so I'll use that as an example. So issues like noise, dust, impacts on water, impacts on groundwater, surface water, pollution, all of those things are able to be considered by the court in merit appeals. And you can bring evidence before the court, because the court stands in the shoes of the original decision maker and makes a fresh decision. Unfortunately, merit appeals are a much harder type of litigation to bring. There's a narrower opportunity to bring those sorts of cases. And of course, there's also third-party enforcement, and that just means, say in a pollution case, some of the ones that EDO have run in the past few years are an example, where you can enforce a breach of the law. So, for example, in a pollution case in the Blue Mountains, we were successful in showing through the court system that there had been pollution by a company, and so that's an example of third-party enforcement proceedings. And now to the Warkworth case. This is all about an open-cut coal mine in the Hunter Valley, of which there are very many now, sadly. That's actually at Camberwell. It's not in Bulga, but they all look pretty much the same. Bulga one's actually much, much bigger than this one, believe it or not. So just the basic facts of the case. Warkworth coal mine, it's a subsidiary of Rio Tinto, and the mine has been around since the 80s, and normally with these large projects they're given approval for about 20 years at a time, and I'm told that the reason for that is that it allows an opportunity for technology to catch up, so they would never be granted a longer period than that, because the conditions that are imposed get old, and you need the opportunity to update the conditions. So in 2003, Warkworth was granted another extension of the mine, but they promised not to come further than a particular point closer to Bulga village. They agreed to protect a certain ridge called Saddleback Ridge, which was a buffer between the village and the mine. And even though in the case the evidence was that the buffer in terms of dust and noise probably wasn't significant, I think from a psychological point of view, in fact not just what I think, we called a social expert from Perth, and I'll talk a little bit more about his findings, but he was very interested in the psychological impacts of coal mining invading on a village, and how that can destroy people's sense of place. And so he gave evidence that this ridge was a very important buffer, even psychologically, as well as perhaps providing some dust and noise amelioration. The mine had also agreed to protect certain remnant vegetation, including endangered ecological communities, in perpetuity, which is basically forever. And some less than 7 years later, they put an application into the Minister for Planning seeking to extend the mine again into those areas that they'd promised to protect in perpetuity, and coming through that ridge that was a barrier for the village. And that was approved by the Planning Assessment Commission under delegation from the Minister for Planning. The impacts of the project included closure of a road, clearing of 766 hectares of 4 types of endangered ecological communities protected under threatened species legislation, the removal of the ridge, and increased dust and noise for residents of Bulga. The court's decision was extremely important for many different reasons. I think for a start, it was the first time a judge of the Land and Environment Court had overturned an open cut coal mine. A couple of months ago, we had a win. 2 commissioners overturned an open cut coal mine, but this was the first time a judge, indeed the Chief Judge of the Land and Environment Court, had overturned approval of a coal mine on merit appeal. So it was a very significant decision, even just from that point of view. I think one of the interesting things about the case is that the Chief Judge looked at this weighting, and you'll recall we've been talking about the weighing of economic, social and environmental. The court really took a fresh look at that weighting process and at the decision making on large projects such as open cut coal mines, and basically said that the range of interests affected, the complexity and interdependence of issues, means that decision making involves a polycentric problem. That is, that the resolution of one issue will have repercussions on other issues, and the other issues may change in nature and scope depending on how the first is resolved. So it was really dramatic to see the court grappling with the complexity of the weighing process, and in a way I think it is quite revealing, because it shows, I mean, you'll recall my slide showing all those different objectives under the Planning Assessment Act. How do you weigh them? And the court here is saying that weighting process is so complex. He described it as like a spider web. If you pull one web, it will have an impact on every single other, part of the web. And in a way, I think the case almost reveals the impossibility of that process, of being able to make that decision in a sensible way. He said the decision maker must determine the relevant matters to be considered in deciding whether or not to approve the project, and subjectively determine the weight to be given to each matter and balance those weighted matters. In this case, it was the social impacts from noise and dust, the impacts on endangered ecological communities, and the economic pros and cons of the development, because not only were there economic benefits that the mine obviously informed the court, but there were also economic detriments, I guess, to the local environment. So it was about weighing up all of those, and the court said this is a subjective determination of the decision maker. And ultimately, he decided to refuse the extension due to significant and adverse impacts on biological diversity, adverse noise and dust, and social impacts on the Bulga village. Now, I think the economic issues in the case are really, really important. The court criticised elements of Warkworth's economic modelling, in particular its attempt to put a value on non-market elements. There is an increasing trend because I guess decisions made and the whole way that society operates is so economic focused. It's all about how much money can we make. So there's a trend towards trying to put a value on non-market things like the environment, water. And it's a way of trying to participate in that economic process. I mean, wild law would say, forget the economics, forget that, just put the environment at the top. But this is really interesting in the way that the court sort of put economics in its place. Instead of saying, well, it's going to make billions of dollars, so the mine is justified as overruling all these other items, the court said no. Economic analysis, such as cost-benefit analysis, is of limited assistance to the decision-making process here, which requires the balancing of economic, environmental and social. And so the court said that the cost-benefit analysis can't replace that weighing process. It's only one element. And he also heavily criticised the non-market valuation that the mine had attempted to do on the EECs. So basically the questionnaires that were part of that process weren't accurate in reflecting how endangered the endangered ecological communities were. So how can you put a value on something if you don't know that 25% of the entire species will be wiped out by this coal mine? So the Warkworth Sands Woodland EEC was one of 4 EECs, or endangered ecological communities, that were impacted by the mine. And the evidence showed that at least 25% of that vegetation would be cleared by the project. That's 25% of that vegetation that is in existence anywhere in the world. And the arguments put forward by the mine was that, firstly, that there were certain grasslands that could be regenerated, and they'd started doing some work with university to try and regenerate that vegetation. And really they were trying to convince the court that there was enough evidence that it would regenerate over time and that it would all be okay. The problem with these sorts of arguments is that you have an almost immediate clearing, but then you have to wait 50, maybe 100 years to see that vegetation grow up. And not only is there no guarantee that that will work, but also how can you say that the regenerated vegetation will match in complexity that vegetation that you've cleared? A problem for the mine was the fact that the Warkworth Sands woodland that was being cleared was of very, very good quality, whereas all of the vegetation to be kept was in a poor quality, or it was in basically a grassland status. So the court rejected the argument about regeneration. The court also said that the biodiversity offsets were not satisfactory. I'm not sure how many people in the room know about biodiversity offsetting. Anyone?
Biobanking.
Well, biobanking is one tool, yes. And basically the concept is that where a developer is going to clear vegetation, and that this is very readily used. It's, as I said before, development is approved and then just conditioned, and biodiversity offsets are always part of those conditions where native vegetation is being cleared. And one of the key important concepts is that the offsets must be like for like. They have to protect the same species. And here the court confirmed that ecological value, that it must be like for like, and that the same species here were not going to be protected by the offset, and that wasn't satisfactory. And in terms of the social limb, we called evidence of the residents, put forward affidavits by the residents about how the coal mine, open cut coal mine, was already affecting their lives in terms of noise, dust, and the social impacts. Couples being awake at 2 in the morning wrestling with who's going to complain tonight. People having to go to work the next day not having slept between 2 and 5, or there was all sorts of repercussions that weren't necessarily what you would imagine to be the immediate impacts, but there were sort of downstream impacts of the mining. Noise and dust conditions that are routinely imposed basically allow for the mine to buy the properties that are most impacted. We call it the zone of affectation. And the court really looked into that and said, well, that causes social impacts too. There was evidence from one lady who had sisters and parents living in the village who said, well, I'm in the zone of affectation, but I don't want to sell. And people ask me, well, are you going to sell your property? And she didn't want to sell, but then what do you do when you know that if you don't, 5 or 10 years down the track, your land will be worth nothing and you won't be able to sell it at any reasonable price? So again, there was a social impact there that was recognised. As I mentioned, we called a sociologist who gave evidence that people experienced damage to their sense of place because they'd moved to this beautiful area, or at least maybe grew up. There was both new residents and people who had been there as fifth generation residents of the village who appreciated the beautiful nature of the bird life, the quiet rural lifestyle, living in tune with the environment. And their whole sense of place had been upset over the years by the coal mine. And so the professor coined this term solastalgia for this loss of sense of place, and the court has recognised that. And so just to, I guess, critique the case and to look at it from an earth-centred approach. I mean, for a start, if we had an earth-centred sort of legal system, the coal mine wouldn't have been approved to begin with, so we wouldn't even have to go to court. But, you know, as I've explained, we don't have that perfect system, so ideally you have the ability to be able to go to the court and on behalf of the environment and have the court decide on these issues. And so really the community group is a conduit or a voice for the environment. Then the environment is a key head of consideration. Well, as Michelle said, you're still stuck with this weighing of the environmental, social and economic impacts. So it's hardly an earth-centred approach. But then there were aspects of the decision that were interesting, like, you know, that offsets have to be like for like. That if you are going to clear vegetation, then you have to have integrity in your plan to try and ameliorate that. The court also placed emphasis more than in previous court cases on the environmental impacts, and in the end upheld for the community their social and environmental impacts as outweighing any economic benefit. The fact that the court took into account the resident concerns and that they were really experts in their own experience was a positive feature of the case. And ecological economics. The court looked very, very carefully at the attempt to value the EEC's, endangered ecological communities, and the social impacts, and found that that methodology that had been used was flawed. I think that is going to be very interesting to see how large projects respond to that in terms of economic assessments that we might see in the future. Hopefully they'll be much more rigorous as a result of this case. Thank you.